Can I have appearances for the state
Pressie Tyner for the state of Florida.
and defense?
Ryan Anderson with the Public Defender's Office.
Okay. Good morning, sir. Can you state your name and date of birth? Okay, sir. I am appointing the public defender to represent you today. You are here on one count of possession of cocaine, one count of possession of drug paraphernalia, and one count of possession of cannabis. I have reviewed the charging affidavit and determined that there is probable cause for the charges. Bond's going to be set on count 1, $500, count 2, $250, count 3, $250. As a condition of release, you are not to use or possess any drugs or non-prescription medications. Anything further from the state?
Your Honor, the state has no objection to releasing him ROR on the marijuana charge.
On the marijuana charge, okay. Defense, anything you'd like to address? No. All right, so on count 3, possession of cannabis, I will release ROR. Best of luck to you, sir. I am on the record. Over here.
State Attorney's Office.
Stephanie Fritchell for the Public Defender's Office.
Thank you. And this is just an additional case from this morning in case it wasn't placed on the record. 23 CF 2409, Stephanie Stafford. That was a 33-day motion. And the motion was denied as an information has been filed. All right, let's see. Mr. Kynek? Mr. Kynek, good afternoon, sir. Can you understand what I'm saying to you?
If you speak slowly, yes.
Okay,
I'm sorry.
that's okay. So, sir, you were arrested. You have 2 new cases this afternoon. You were arrested in 23 CF 3688. This was pursuant to a probable cause warrant for throwing or shooting into an occupied structure or dwelling. The bond in that case is $2,500. You are not to return to the scene. No contact with the victim or state witnesses, and no weapons or firearms. You were also arrested in 23 CF 3755 for possession of cocaine, possession of drug paraphernalia, and possession of cannabis less than 20 grams.
I don't have that for him, Your Honor.
You don't?
I just have the CF 3688.
Sorry, it's connected here, but it's actually for Mr. Brian Key. Are you Mr. Key?
No, that's the signature, Your Honor.
Do we have a Brian Key for this afternoon?
Yeah.
We do? Okay, all right, it was just attached. Oops, that's okay. All right,
Your Honor, he does also have an out on bond. That is 22 CF 11608. That is also, it's an aggravated battery, great bodily harm, criminal mischief, and another battery. That's with the same victim of this case, Your Honor. And based on that, the state is going to be asked that you revoke the bond, the out on bond, and hold him at no bond, Your Honor.
I was gonna do that anyway because the alleged offense date for the new law is January 29th of 2023, and the arrest date for the out on bond is December 4th of 2022. So
Your Honor, we understand the court's position. However, due to his limited history, if you look at the face sheet, we'd be asking that the bond not be revoked. If the court is inclined, maybe revoke and double as opposed to no bond.
Okay, that request will be declined. I'm going to revoke the bond and it's going to be set at none.
And just so Mr. Kanak is aware, a ICE hold was added for him.
So you also have an immigration detainer.
Excuse me?
You have an immigration detainer. Someone from ICE is going to come and speak with you. Okay, thank you, sir. Yes.
I have no bond. So what's gonna happen? I didn't understand. Which attorney? So I have criminal attorney. Or I'm gonna talk to in the like, can I call you here? Mhm. So if I pay this month. So how I'm gonna solve this problem? I didn't get it. My criminal attorney?
Thank you, Your Honor.
Sure. Good afternoon, sir. Your name?
Good morning, Your Honor. My name is Marcus Darius.
Mr. Darius, sir, this is 23 MM 1979. You were arrested for trespass in an occupied structure. There is probable cause. I'm going to appoint the public defender to represent you. Is there an offer for Mr. Darius?
Yes, there is. The offer is an adjudication of guilt, credit for time served, and no return to Hertz at Orlando International.
All right.
Your Honor, can I say something?
Did you want to accept the offer?
Can
Mr.
I
Darius?
say something? Can I speak for myself as an authority and official?
Sure. Go ahead, sir.
Due to the fact of official ID and authority under the Real ID Act and it under the order of federal law,
Okay,
because the federal compliant ID, which is a federal ID now,
okay.
according to the state of Florida,
Uh-huh.
I accordingly exercised myself accordingly, and I did have a warrant. And I also am Office Inspector General, which is Inspector General Criminal Investigator for CIA, and I'm also a Fed employer. Now, from my understanding, what took place, I explained to officials, I explained to a couple of authorities that's there that know I'm occupying, but also exercising myself
got
as
it.
authority and official.
Thank you. I got it.
Illegal.
Mr. Darius, I got it. Thank you for your explanation. Thank you. So at this time, Mr. Darius, I am going to stay your bond at $500. I'm going to order that you're not to return to the Hertz at the airport. And then I think someone from the Public Defender's Office will probably come and talk to you about what your options are, sir.
I would want
All
to take
right.
my options right now.
Well, I don't.
So
think
with
we'll
that
be able
being
to do
said, I'll take a nolo conjunte due to the fact that I'm not willing to comply with the offer I am getting, which is
Yeah.
You're going to talk to your attorney.
Right. I'm not, I think we're going to need to figure out what your options are and maybe resolve it on another day. Okay? Thank you,
Oh, so I'm
Mr.
being held a
Darius.
little longer, or?
Yes, just a little longer.
Okay, no problem.
Okay, thank you, Mr. Darius.
Bond out, you do have a bond. Okay.
Oh,
Strickland.
I know, I feel like I know Mr. Key.
No offer. Oh, I see.
Is this Mr. Key?
No, Your Honor, Mr. Key is a sign interpreter, so can we put him to the side?
Sure, that's fine.
Sign interpreter, show up.
No problem. Mr. Strickland?
Yes, ma'am. My name is
All right, Miss-
Emmanuel Bartholomew Strickland.
Yes, sir. This is 23 MM 1969. You were arrested for battery. There is probable cause. I'm going to appoint the public defender to represent you. You were also arrested in 23 MO 386 for an open container.
Yes, ma'am.
Hold on.
I
Let me just-
apologize to interrupt.
Mr. Strickland. Mr. Strickland, let me finish telling you everything that I need to tell you, and then I'll give you an opportunity to speak.
Yes,
okay?
ma'am. Yes, ma'am.
Thank you.
I apologize.
That's okay. I also don't want you to talk to me about your actual case. So if you have questions about what I'm gonna tell you, happy to answer those for you. Otherwise, I don't want you to talk to me about your case. You can talk to Ms. Fritchall, but everything in this room is recorded.
I understand.
Okay. All right, so what I was saying to you is that the second case that you have is for an open container, and there's probable cause in that case as well. I'm going to appoint Ms. Fritchall to represent you, her office to represent you. What did you want to tell me?
I am guilty of an open container.
We'll talk about it more later.
Okay.
We'll waive his appearance, Your Honor.
I was in front of many cameras and I
Okay.
was in front of.
I hear you. I hear you. Mr.
did
Strickland, you don't
not
have to explain.
touch
Mr.
the
Strickland, I want to stop you. Just listen to me. You don't have to explain. I want you to answer some questions for me though, okay?
Yes, ma'am.
So, Mr. Strickland, where are you currently staying?
Currently, I'm staying in, I just got out of the hospital yesterday. And I'm staying in the, on the street.
Okay. What happened to your eye?
I was shot in the face and sliced because somebody thought I was someone else. And my nurse showed me a picture. I do look just like the guy.
Oh my God.
But yeah, I spent a month in the hospital.
All right. Well, it sounds like you need to be taking care of yourself.
Yeah, no, I do take medication. I have medication I take. And also I was going to check myself back into the hospital.
Okay. Do you know where the Orange County Courthouse is?
The Orange County Courthouse, yes, ma'am. I
All
do
right.
know where it is.
Okay. So, Mr. Strickland, listen to me. You are not to return to 255 South Orange Avenue. Do you understand? The place where you were arrested?
Copy that, I understand that.
Okay. You're also not to possess or consume any alcohol or controlled substances without a valid prescription. Do you understand that?
Yes, ma'am.
All right. You're also not to have any contact with the security guard or the alleged victim in your case. Do you understand that?
Copy that, yes, ma'am.
All right. No, you can't possess any weapons or firearms.
I will not.
Okay. So I'm going to release you on your own recognizance at this time. All right? Get whatever medical care you need. Make sure you're at your court date. When you leave here, they're going to give you a court date. You must appear back in court on that date where you're going to get arrested.
Copy this.
All right.
Your Honor, that's for both cases?
Did you have an offer from on the open container?
I did. It's an adjudication and credit time served.
Do you want to get rid of the open container case?
We can get
Your
rid of
Honor,
open container, credit time served.
just because
and I will attend the
they're
court date
connected.
that,
I think we're just going to keep them together. I think your lawyer might have some ideas that she wants to talk with you about the case. Okay? So just make sure you appear on both of those cases.
okay, they'll both be on the same court date.
They will.
All right.
Okay. Thank you, sir.
And what was the court date you had
They're going to give it to you when you leave. I don't know.
Yes, ma'am, thank you.
Thank you.
Can you hand me the, oh, you don't have.
Good afternoon, sir. Your name? What is it? Mr. Burgos, this is 23 MM1991. You were arrested for loitering or prowling. There is probable cause. I'm going to appoint the public defender to represent you. Was there an offer for Mr. Burgos?
Adjudication and credit time served?
Your Honor, there is an offer in this case. However, we would be asking if he can be released on his own recognizance today to further discuss this case instead of resolving. The offer is an adjudication of guilt credit for time served.
Do you have good contact information for Mr. Burgos?
Can I get a phone number from you? Your Honor, we can provide our contact information so that he can reach out to us and we can stay in touch with him and make sure that he does not miss any future court dates and he's aware of them.
All All right, Mr. Burgos, are you aware of where the Orange County Courthouse is?
No, I'm not.
Okay. Ms. Fertel, you will make sure that he knows where that is. It's on Orange Avenue. Are you familiar with downtown Orlando?
Is it close to Amelia Street, if I'm missing it? I think I know
Yes.
exactly where it is.
Yes, it's on, yeah.
Okay, so you're gonna need, when they release you today, they're gonna give you a court date. You need to make sure that you reappear at that court date for your arraignment. Okay, if you don't, they're gonna arrest you. So I'll release you on your own recognizance, no return to the scene, no
To where this incident happened.
Westmoreland Avenue and West Washington Street.
To Westmoreland.
That was a corner of an intersection.
Well, you can't go back there,
Don't go back there. Just avoid that intersection.
All right.
all right? No weapons or firearms, sir.
Okay.
All right? Thank you.
Take this, contact us when you get out. We have your new phone number, okay?
Good afternoon, your name, sir?
Good afternoon, miss. My name is Kenroy Douglas.
Thank you, Mr. Douglas. This is 23MM135. You were arrested for resisting officer without violence. There's probable cause. I will appoint the public defender to represent you. Was there an offer for Mr. Douglas?
There was an offer by the state. The offer was a withhold of adjudication and credit for time served.
Mr. Douglas, did you wish to accept that offer, sir?
Yes.
Did you have an opportunity to read the plea form?
Can you repeat that question?
Sure. Did you have an opportunity to read the plea form that's there in front of you? Or review it with your lawyer?
Oh, I didn't get this fit.
You did not receive the form? Okay. Do you want,
I got several from, but didn't think I get that promise.
okay. Do you understand, sir, that by taking this plea today that you are going to give up your right to have a trial by a jury?
To give up my rights to have a trial by
A jury,
jury.
correct.
So meaning it will try without a jury.
It'll be over today. You're gonna enter a plea.
Okay, thank you.
You understand that?
Correct.
Okay. You also understand then you won't be able to present any evidence, witnesses, or defenses on your own behalf. So you won't get to say that the state of Florida can't prove this against you, that you didn't do it.
Oh, that's what.
If you would like to contest this case, you wouldn't enter a plea. That's what the rights on the form say. So, well, do you understand that? And you wish to give up those rights?
I mean, those rights are not a right that in my and based on my arrest because it wasn't truth, but this is what it is. So
You believe this to be in your best interest? Is that what you're saying to me?
actually, I'm not saying, I didn't say that. I'm just saying, if you don't mind me expressing myself to the court.
Just don't talk about
Briefly.
the facts of the case.
No, it's just briefly. In the situation, there wasn't justice, and I'm here, and this is what the court ruling is, and this is what it is in the court. I don't have much to defend myself on without having the fair grounds from the beginning.
Okay. I just want to make sure that you understand that you don't have to resolve your case today. You could come back to court on another day and make the state of Florida prove that you're guilty.
If I come back, I still can't even prove that.
I don't know. I'm just asking you if you understand you're giving up the,
I'm gaining understanding. I'm reading, I'm learning, I'm listening.
okay,
I'm patient.
okay. Do you are you under the influence of any drugs, alcohol, or medication that would affect your ability to understand what we're doing today?
Clicking very sharp.
Okay. And are you currently on probation?
No, I don't. I wish not to be.
Do you understand, if you are not a U.S. citizen, that this plea will subject you to deportation?
I've been through that already.
Okay.
So right now I'm a U.S. citizen because I've done the right thing. If you check my record,
Okay.
like Jesus foot bottom.
So, Mr. Douglas, that question was not personal to you either. I have to say that to everyone. Okay. So at this time, I'm going to accept your plea, withhold adjudication, sentence you to 1 day in the county jail. You've got credit for 1 day time served. You will have to pay court costs. Those will be due 1 year from today, or you need to see the clerk of the court for a payment plan. Make sure you get those paid, otherwise they will suspend your driver's license, okay?
So could you please explain clearer so I can understand clearly what you were saying at the.
So as a result of today's case, you do have to pay court costs associated with the case. All right, I've given you 1 year to get those paid.
Okay.
All right, if you don't, they will suspend your driver's license. Okay, thank you, sir.
Thank you very much. Have a nice day. I appreciate
You too, sir.
it. Okay, I'm gonna sign in common letter. All right, thank you very much.
Have a nice day, sir.
Same to you, sir.
Thank you. Oh, we could do them at the end. Yeah, is that okay? Does that work for you all? Yeah, it's fine.
I believe that was the reset, right, Your Honor?
You asked when, and I said at the end. Is that
That's fine, Your Honor.
Who, I'm sorry, I don't.
For the reset from this morning, Mr. Nguyen?
sure,
Okay. I just wanted to make sure for corrections that it wasn't posing an issue. Mr. Lorgia? You, Mr. Lorgia? All right, sir, good afternoon. This is 23 MM 134. You were arrested for loitering or prowling. There is probable cause. I'll appoint the public defender to represent you. Ms. Eugene, did you have an offer for Mr. Lorgia?
It's an adjudication and credit time served, Your Honor.
Mr. Lorgia, did you want to accept that offer?
Upset the
Excuse me?
upset the
You'll accept it? Okay. Did you have an opportunity to read the plea form, sir?
yes, ma'am.
Do you have any questions about any of the rights that are on the form?
No, ma'am.
Are you on probation?
No, Your Honor.
Do you understand if you're not a U.S. citizen that this plea will subject you to deportation?
I'm aware of it.
You what?
I'm aware of it. Yes.
You understand?
Yes.
Okay. And Mr. Lorgia, at this time, I'm going to accept your plea, adjudicate you guilty, sentence you to 2 days in the county jail. You've got credit for 2 days' time served. You will have to pay court costs. Those will be due 1 year from today, or see the clerk for a payment plan. At this time, sir, I'm not going to take any action on your out on bond case. You're all set, sir. Thank you. Good luck. We're gonna be long. Ms. Fritchall?
Yes.
And Ms. Eugene, on Mr. Key, Brian Key, it's 23 CF 3755. That's the case that needs the sign interpreter. The interpreter's not available until later this afternoon, so they're gonna schedule it for tomorrow. But what I was gonna do is appoint your office, Ms. Fritchall. It's a felony case, so he can't resolve it anyway. And then set the bond, so I'll IA him. That way, if he wants to post bond, he can, but then reset it for tomorrow. If he's not gone, that he'll be brought back and we can talk to the judge tomorrow about that.
Understood.
If he needs to. Is that fine?
Defense is agreeable.
Okay. So then, in that case, I will appoint the public defender's office. He was charged with possession of cocaine, possession of drug paraphernalia, and possession of cannabis less than 20 grams. There's probable cause. Bond on count 1 will be 500. Bond on count 2 is 100. Bond on count 3 is 100. No return to the park. That's Mr. Key's case. He needs to come back tomorrow if he hasn't bonded out. Okay, that's all right. And if you want to, just set that one aside, I'll tell you. It's easier for you. Yeah, that way we don't forget. Okay. Is this Mr. McLeod?
Yes, ma'am. Good morning.
Good morning, sir, or good afternoon.
Good afternoon.
This is 23 MM 1966. You were arrested for resisting officer without violence and trespass in a conveyance. There is probable cause. I'm going to appoint the public defender to represent you. Ms. Eugene, did you have an offer on this case?
Adjudication of guilt and credit time served.
Was Mr. McLeod going to accept that offer?
Yes, ma'am.
think you already signed this one, didn't you? That's all we're handling today. Is nothing else is holding you, got nothing else going on. As long as she doesn't touch. Hold on, sorry. Good job, Abigail. Wasn't the. Yeah, that's the sign language interpreter. She set the bond, and she's resetting it tomorrow. We can't get the sign language interpreter here today.
I'm not comfortable accepting the plea on this case today. I'll stay the bond at 500 on count 1 and 250 on count 2. I'm also revoking the bond in 22 CF 1402. That bond's gonna be set at none.
So, that case you were out of bond, just revoke the bond. If there's no bond, you'll have to talk to your attorney on that case regarding that, okay? Take this with you? You-
Same. Is this, well, good afternoon, sir. Tell me your name, please.
My name is Morgan Oliver Smith. Nice
Mr.
to meet
Smith?
everyone.
This is 23 MM1983. You were arrested for trespass on property after warning. There is probable cause. I will appoint the public defender to represent you. Is there an offer for Mr. Oliver Smith?
It's an adjudication of guilt, credit time served, no return to the Chevron, located at 4985 Old Winter Garden Road.
All right. Mr. Oliver Smith, did you want to accept that offer, sir?
Yes, ma'am.
Did you have an opportunity to read or review this plea form with your attorney?
Yes, ma'am.
Do you have any questions about any of the constitutional rights on the form?
Not at this time, no, ma'am.
Are you on probation?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that this plea will subject you to deportation?
Yes, ma'am.
I will accept your plea, adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. You are not to return to the Chevron, and you will also have to pay court costs. Those will be due 1 year from today, or you need to see the clerk for a payment plan.
Okay, thank you.
Thank you, sir. Sir, good afternoon.
Good afternoon, Judge.
This is 23 MM 1964. You were arrested for trespass in a conveyance. There is probable cause. I'm going to appoint the public defender to represent you, sir. Your bond on count 1 is $500. and I am revoking the bond in 22 CF 9553. That's going to be set at none, sir. Thank you.
Thank you.
And Your Honor, what was the bond on this case? I apologize.
500?
500? So resolved today because you're revoking the bond on the other one. Okay, so even though there was an offer to resolve,
See,
you're gonna have to talk to your attorney and note that you were out on bond and see what they can do to help you out, okay? Take this, contact them. Look.
Did Mr. Velasquez bond?
Mr. Velasquez, mental health, Your Honor.
Okay. I'm going to appoint your office, Ms. Fairchild. Did you want to waive his appearance?
I apologize. Who were we on?
On Mr. Velasquez? George Velasquez?
Yes, Your Honor.
That's 23 MM 1986. The public defender is appointed to represent him. There's probable cause. He's not to return to the scene, have any contact with the victim, or possess any weapons or firearms, and bond is $500.
Thank you, Your Honor.
Mr. Barnes, or Ms. Barnes?
Yes.
Good afternoon, ma'am. This is 23 MM 9. You failed to appear for arraignment on the offense of petty theft of $100 or more. Was there an offer for Ms. Barnes?
Yes, Your Honor.
It's a withhold of adjudication, credit time served, no return to the Walmart located at 1700 South Orange Blossom Trail. There's also a cost of investigation of $210.25 to the Apopka Police Department.
Got it. All right. Ms. Barnes, did you have a chance to read and review that plea form with your attorney?
No, ma'am.
No? You didn't read the form that you just signed?
Oh. I apologize, Your Honor. I didn't realize that we haven't gone over it with her at this time.
Ms. Barnes, do you understand that by entering into this plea today, we're not going to have a trial on your case?
Yes. Yes, Your Honor.
Okay. That by entering into this plea, your case will be finished today.
So, the record as a withhold of adjudication is not a criminal conviction, but it is on your record, okay? So it's something to be aware of. So it would resolve your case. Obviously, you have the right to fight the charges against you and to speak to your attorney more, or you can resolve it as it is today, as the judge is telling you. Is that what you want to do? You can resolve it today with this offer, or you can take more time, speak to an attorney, and see how you want to resolve the case. Okay. She wishes to resolve.
All right. So you understand the constitutional rights on this form that you're giving up?
Yes, Your Honor.
Okay. Are you currently on probation?
No.
Do you understand if you're not a U.S. citizen that this plea will subject you to deportation?
Yes.
At this time, I'm going to accept your plea, withhold adjudication, sentence you to 2 days in the county jail with credit for 2 days' time served. You are not to return to the Walmart. You'll need to pay court costs, including the cost of investigation, to the Apopka Police Department in the amount of $210.25. Those will be due 1 year from today, or you need to see the clerk of the court for a payment plan.
So I have to stay the night again?
No, ma'am. You'll be released today if you have no other holds.
Okay.
Thank you.
The court costs, because it'll suspend your driver's license if you don't, okay? And that might cause other issues, and then you might end up being back here in the future, and you don't want that. So pay the court costs and stay out of trouble. Good luck.
You're welcome, ma'am. Are you Mr. Kyoho?
Yes.
Sir, this is 19 MM 8299. You failed to appear for pretrial conference back in 2019. Was there an offer for Mr. Kyoho?
Yes, Your Honor, there is. Sorry.
It's an adjudication of guilt, credit time served, and no return to Lake Eola. There's also a cost of investigation of $58.58 to Orlando Police Department.
Sir, did you want to accept that offer
I can never go back to Lake Eola ever?
not for a year?
A year? Oh, that's fine. That's fine. As long as I go back one day, it's a good lake.
Okay.
I thought that meant forever.
No, but if you,
That's where the Leviathan is in the Bahamas.
all right, but listen,
Right.
if you go back there, they're gonna arrest you. Do you understand?
Yes, 1 year.
Got it. Okay.
you.
So, sir, Did you read this or review this plea
Yes, yes,
form?
I came here from Miami. I had a warrant, bitch warrant there. They picked this up. I just came back to resolve it. It's been 4 years, I think, almost.
Yeah.
I can pay the 58,
That's fine.
82, everything. I just wish to resolve credit time service finally. Thank you.
That's what we're gonna do. I just have to go over a couple things with
Okay,
you first, okay? All right, so I just want to make sure that you either read or reviewed the plea form with
Yes,
your lawyer.
yes,
And
yes.
you understand the constitutional rights you're giving up.
Yes, yes, I do.
All right, and you're not on probation?
No, no, ma'am.
All right, and do you understand if you're not a US citizen that this plea will subject you to deportation?
Yes, ma'am.
All right, so well, at this time, I'm going to accept your plea, adjudicate you guilty, sentence you to 2 days in the Orange County Jail. You've got credit for 2 days' time served. You are not to return to Lake Eola. The trespass is good for 1 year,
Yes, ma'am.
okay? And
Okay, okay.
you're gonna have to pay court costs, including the $58.58 to the Orlando Police Department. Those will be due 1 year from today, or you need to see the clerk of the court for a payment plan.
Okay.
All right, you're all set. Have a good day, sir.
Good luck with everything.
Mr. Diaz? Good afternoon, sir. This is 23 MO 388. You were arrested for open container. There is probable cause. Was there an offer for Mr. Diaz?
Yes, Your Honor.
It's an adjudication of guilt and credit time served. Your Honor, for all of the city cases, it's an adjudication of guilt and credit time served.
Thank you. Mr. Diaz, did you have an opportunity to read this plea form or review it with your lawyer?
No, I plead guilty.
I know you do, but I have to, I think we know each other. I think we've seen each other before. So I know you know, but I have to ask you if you did read this plea form for this case and you understand the constitutional rights on this form. Okay. And you're not currently on probation? And you understand if you're not a US citizen, this plea will subject you to deportation?
Yes.
All right. I'll accept your plea, adjudicate you guilty, sentence you to 2 days in the Orange County Jail. You've got credit for 2 days' time served. You will have to pay court costs. Those will be due 1 year from today, or you need to see the clerk of the court for a payment plan. All right, take care, sir.
Thank you.
This is Mr. Hammer.
Yes, good morning, afternoon.
Good afternoon, sir. This is 23 MO 390. You were arrested for stealing passage to amusement. There is probable cause. I'll appoint the public defender to represent you. It's my understanding that the offer is an adjudication of guilt and credit time served, no return to Universal. Would you like to accept that offer, sir?
Yes, I will.
Okay. Did you have an opportunity to read or review this plea form?
I did, Your Honor.
Do you have any questions about any of the constitutional rights you're giving up?
No, Your Honor.
Are you on probation?
No, Your Honor.
Do you understand if you're not a US citizen, this plea will subject you to deportation?
Yeah, I'm a U.S. citizen.
Okay, so I will accept your plea, adjudicate you guilty, sentence you to 2 days in the county jail with credit for 2 days' time served. You will have to pay court costs. Those will be due 1 year from today, or you need to see the clerk for a payment plan.
Okay, I'll see the clerk.
All right, thank you, sir.
Thank you.
Mr. Johnson? This is 23 MO 391. You were also arrested for stealing passage to amusements. There's probable cause. I'll appoint the public defender. Did you want to resolve your case today, sir?
Yes, Your Honor.
All right, and the offer is the same to you as an adjudication of guilt, credit for time served, no return to the Universal.
Okay.
Is that acceptable?
Yes, ma'am.
Okay, did you have an opportunity to read the plea form or review it with your lawyer?
Yes.
Do you have any questions about any of the constitutional rights you're giving up?
No.
Are you on probation?
No.
Do you understand if you're not a US citizen that this plea will subject you to deportation?
I'm a U.S. citizen.
I will accept your plea, adjudicate you guilty, sentence you to 2 days in the county jail. You have credit for 2 days' time served. You will have to pay court costs. Those are due 1 year from today, or see the clerk for a payment.
Okay.
Thank you, sir.
All right, thank you.
Mr. Mosley? Good afternoon, sir. This is 23 MO 392. You were arrested for disorderly conduct. There is probable cause. I'm going to appoint the public defender to represent you. The offer to resolve your case today is an adjudication of guilt, credit for time served in court costs. Did you wish to accept that?
Yes, ma'am.
Did you have an opportunity to read or review this plea form with your lawyer?
Yes, ma'am.
Do you have any questions about any of the constitutional rights on the form? Are you on probation? Do you understand if you are not a U.S. citizen that this plea will subject you to deportation? I will accept your plea, adjudicate you guilty, sentence you to 2 days in the county jail. You have credit for 2 days' time served. You will have to pay court costs. Those will be due 1 year from today, or see the clerk for a payment plan. And I'll take no action on the out on bond case. Thanks, sir. Good luck. Are you Miss Murphy? Miss Murphy, good afternoon. This is 23 MO 393. You were arrested for urinating in public. There's probable cause. I'm going to appoint the public defender to represent you. If you wanted to resolve your case today, ma'am, it would be an adjudication of guilt and credit for time served along with court costs. Do you wish to accept that offer? Yeah. All right. Did you have a plea form there? Ms. Murphy, do you have any questions about any of the constitutional rights on that plea form?
No, ma'am.
Are you on probation?
No.
Do you understand if you're not a U.S. citizen that this plea will subject you to deportation? Was that yes? I'll accept your plea, adjudicate you guilty, sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. You're gonna have to pay court costs due 1 year from today or see the clerk for a payment plan.
Okay.
Thank you. Are you Mr. Rosario? Rio? No? Did Mr.
You have the booking number, Your Honor?
Rosario Bond, why can't I find it?
It'd be 2300.
Like completely just, oh, 23007422. I'm thinking he bonded.
Yes, they surety bonded.
You're Mr. Allen?
Yes, ma'am.
All right. Mr. Allen, this is 23 CF 3343. You were arrested pursuant to a probable cause warrant for burglary to an unoccupied structure, retail theft, and trespass on property. I will appoint the public defender to represent you. You're not to have any contact with the victim, and you're not to return to the scene. Your bond on count 1.
Where was this at?
Hold on, wait, just a second. Mr. Allen, at this time, I'm gonna place you on pretrial release, sir, okay? Thank you.
Your Honor, I also ask that he have no contact with the co-defendant. Co-defendant is Cindy Moore Woodard. It's the same case number.
Okay. Mr. Allen, listen to me. You can't have any contact with your co-defendant, do you understand? Okay, thank you.
Pretrial release, essentially, you're going to be reporting to
PTR. Mm-hmm.
Thank you, ma'am.
You're welcome, sir.
Sarah Allison is behavior, Your Honor.
I'll find a waiver of her appearance based upon her inability to come to court due to her behavior in 23 CF 3757. I'll appoint the public defender to represent her. Her bond on count 1 is $3,500. Her bond on count 2 is $500. She's not to return to the scene or have any contact with the victim or possess any weapons or firearms.
Thank you, Your Honor.
Mr. Benjamin?
Benjamin, yes.
All right, so just give me 1 second.
It's an F2.
Thank you. Mr. Benjamin, this is 23 CF 3752. You were arrested for lewd and lascivious behavior and exposure of sexual organs. There is probable cause. I will appoint the public defender to represent you.
Which I didn't ask for.
Your bond on count one, sir, is $5,000. Your bond on count two is $500. You are not to have any contact with any children under the age of 18.
You're talking to my straw person, okay.
Pardon me?
You're talking to my straw man. I'm flesh and blood. I'm not the one that was.
I got it. Thank you. Any other conditions, Miss Eugene?
Unfortunately, not, Your Honor. This happened at his home,
I
so
know.
I can't think of anything else, Your Honor.
Okay.
Closes blinds?
Well, and I guess no contact with any of the victims.
Yes, Your Honor.
All right. All right, thank you, sir.
Stay in touch.
Scott Inclon, behavior, Your Honor.
All right, I'll find a waiver of his appearance based upon his inability to come to court due to his behavior. He was arrested in 23 CF 3736 pursuant to a probable cause warrant for contempt of court and obstructing justice. Bond on count one is 100, bond on count two is 2,500. There's no contact with the victim. I'm not revoking the bond in 23 MM 1301 because the offense date on the arrest for that case and the warrant are the same. However, the offense date on 23 CF 1460, or his arrest date, was 2/1 of 23. And so that bond will be revoked and set at none.
In which case was that? I apologize.
These two out on bond, so I'm not taking any action on the misdemeanor, the 23 MM 1301, but the 23 CF 1460, that one I'm revoking. The offense date or date of arrest is February 2nd, and the alleged offense date in this warrant is 2/24.
Okay, thank you, Your Honor.
Mr. Garner?
Yes.
All right, sir. This is 23 CF 3763. You were arrested for possession of cocaine within 1,000 feet of a convenience store, possession of cocaine, destroying evidence, possession of drug paraphernalia, and littering. I will appoint the public defender to represent you. Hold on.
You know, and
Just a second.
watch what you, don't say anything at all. It's all being recorded.
I find probable cause for counts 1, 2, 4, and 5. I do not find probable cause as to the destroying evidence as to count 3. Mr. Garner, you are not to return to the scene, sir.
Any way we can get an OR? 'Cause I have no money.
I need to ask you, though, if you know where the courthouse is.
Just to tell me where it's at and I will be there.
All right, so the Orange County Courthouse is right down on Orange Avenue, downtown Orlando, Florida, okay? Ms. Fritchall's gonna give you a green paper that is going to tell you how to get in contact with her office. You need to appear at that court date, otherwise a warrant will be issued for your arrest, and you are not to possess or consume any controlled substances without a valid prescription.
No problem.
All right, sir.
Is that an ROR?
Yes.
Thank you.
Agree.
Don't forget your other paperwork.
Good
Your Honor, I
answer.
do have a PC argument on this one.
Okay, sure. Let me just read the case and then I'll let you make your argument.
Absolutely.
Ma'am, tell me your name, please.
What happened?
Tell me your name.
Desi?
Is your last name Henbest?
Yeah, they have me under that ID, but I have somebody kin to me that's older than me. I was actually born in '86, so they got my identity a little mixed up in my information, but I'll carry on as whatever y'all's using here.
What's your name?
My actual name was Clara McGrath, date of birth 3/18/1986. But the cops, they stick me under this information.
Well, I'll have them make a note of that other name and birthday, okay?
Thank you.
Sure. But Megan, her print's cleared and everything, right?
Yeah.
Okay.
Her prints are cleared. She's been identified.
All right, well, we'll make a note of that. All right, so this is 21 CF 12338. Ma'am, you failed to appear for court on March 2nd of 2023. Your bond in that case is set at none. I'll appoint the public defender to represent you if they weren't previously appointed. You were also arrested in 23 CF 3748, and I'll appoint the public defender in that case. Ms. Fritchell, you wanted to be heard?
Yes, Your Honor. We, as the defense, would be arguing no probable cause to the burglary portion. This would be simply a trespass, as there is no intent to commit a crime therein. We understand that the police report states that there was a broken window. However, the police weren't sure who broke the window. I don't see any evidence that supports it, and she's not here for a criminal mischief, meaning that they themselves likely didn't believe there's enough probable cause. Therefore, based on the four corners of the information in front of us, the police report, I don't see any intent to commit a crime therein, and we'd be arguing that this is a mere trespass.
Ms. Eugene?
No objection, Your Honor, and if the court is agreeable, the statute for trespass is 810.08 sub 2 sub A.
Thank you very much. I agree. I don't believe that the affidavit established that there's probable cause for a burglary. And Madam Clerk, did you get the statute number?
I think so, but she might not. be able to
810.
touch it, so hang on one second.
810.08
The bond?
sub
You're
2
gonna
sub
have to
A.
go in front of that judge to get your bond back, okay?
Yeah, because I'm kind of confused.
And bond in that matter is gonna be set at $500.
Yeah, that's
So
the one
this
that's
is,
confusing.
the new case is 500,
No return to the scene, no contact with the victim.
and then I think,
Ms. Henbus, did you hear what I said?
Yes, ma'am.
Okay.
did you, I do want to make sure you heard, because I was talking.
Yes, it is. It is.
That's a little bit of an issue.
You don't have to talk. Well,
Okay, because my,
what's the issue?
I'm requesting that they get my credit report from TransUnion because it'll show that address on my credit report. So I want to have verification that I wasn't actually trespassing illegally.
Then we'll talk to your attorney about that.
Okay,
That's
all right,
facts of the
all right.
case. We'll talk to them about it. Okay. Let me check the other one. I apologize, Your Honor.
It's all right.
Call the attorney, public defender's office, that number right there. You can also jail mail, and they'll get in touch with you and talk to them about this case, okay?
All right. Otherwise, where am I go back
The
to
other
court?
case is, it's a felony as well. You'll get your court dates when you go back there, okay? Or
Okay.
actually, we'll let you know your court dates when you contact us.
Are you Mr. Hill?
Yes, ma'am.
Mr. Hill, you are here in 23 CF 3675. You were arrested pursuant to a probable cause warrant for burglary of an occupied structure and petty theft. I will appoint the public defender to represent you, sir. You are not to have any contact with the victim or witnesses, and you are not to return to the scene. Your bond on count 1 starts 3,500. Your bond on count 2 is 100. Thank you.
I think we're here for that today, so you have.
Mr. Judy? Did I say that correctly?
Yeah, it's pronounced Judy, but you can call me Judy.
Yeah, your last name is Judy? Yeah. Sir, this is 21 CF 15095. You were arrested because you failed to appear for a VOP hearing on February 7th of this year. At this time, your bond is set at none. I will appoint the public defender to represent you, and you will see Judge Lattimore in about a week. Thank you, sir.
Contact our office. You have no bond right now. Talk to your attorney about it, and they'll explain in more detail what's going on. You can talk to them about if you can get a bond or not, okay? Good luck. Let's hear what the judge says really
Good
quick. and then
afternoon,
we'll-
sir. I will answer a question for you if I can
And I
after I
do-
tell you the things I need to tell you, but I do not want you to talk to me about the facts of your case, okay?
And I do have a probable cause argument for this one.
Okay. This is 23 CF 3743. You're Mr. Jones, correct? And you were arrested for possession of cocaine with intent to sell or deliver with a firearm, possession of oxycodone, possession of a firearm, and the commission of a felony, possession of cannabis with intent to sell with a weapon, possession of a Lazapram with intent to sell, possession of a controlled substance with intent to sell. Ms. Fritchell, your argument?
Yes, Your Honor. It's the defense's understanding that all of these substances were found in a backpack, the backpack located in a vehicle that belonged to the driver, who was not Mr. Jones. The vehicle was acknowledged to belong to the driver. I believe he had the keys as well. Additionally, the backpack was not tied to Mr. Jones in any way. There's no identifying factors, nothing to say it was his backpack. Considering that he was not the vehicle owner, considering that he did not have the keys to the vehicle, and that nothing in the backpack tied him to it, we would argue lack of probable cause.
Ms. Eugene?
I just wanted to make sure that the backpack was found in the back seat. I read one where it was found in the trunk and one in the.
Okay, no problem. Take your time.
Hold on one second. Let me review
Your
this.
Honor, my argument is that the backpack was found in the back seat and it was within reach of both of them. So this is constructive possession, Your Honor, as both of them denied ownership of the bag. So it's constructive possession.
So, Ms. Fritchell, I certainly understand your argument, which is an argument that I'm sure will be made at trial. But in terms of probable cause, that standard has been met. So I do find that there is probable cause. I'm going to stay the bond as to each count, order that you're not to possess any weapons or firearms, sir, or have any contact with your co-defendant. I'm also revoking the bond in all the out-on-bond cases. Those are going to be set at none. Thank you, sir.
Contact your attorney. You have bond on some of your cases, but some of them are no bond, so you'll have to contact them, okay?
Roy King, refuse, Your Honor.
Ms. Eugene, is that the statewide case, do you know?
No, the statewide is Scott Thompson, I believe.
Okay,
Well, actually, this might be, but the one that I was made aware of.
okay. I'm
Thompson.
gonna recheck my email because,
Your Honor, that's correct. It is Mr. Thompson, Mary Salmon with the Office of Statewide Prosecution.
oh, hi there, I didn't know you were on the line.
Yes,
Okay,
I'm covering for Ashley Wright. That's her case. But yes, that's 2023 CF 3734 and 3747.
okay, all right, we're not quite there yet. I just didn't know, this one appeared like it might be one of your cases, but it doesn't look like it is.
We're still on Roy King, just to clarify, correct?
Yeah. I'm gonna find a waiver of Mr. King's appearance based upon his inability to come to court due to his behavior in 22 CF 11458 BO. I'll appoint the public defender to represent him. He was arrested for human trafficking, deriving support from proceeds of prostitution, and unlawful use of a two-way communication device. His bond on count 1 is 25,000, his bond on count 2 is 5,000, his bond on count 3 is 1,000. Ms. Kaiser?
No conditions, Your Honor?
Yes, ma'am.
Yes, no contact directly with the victim, co-defendant, or witnesses.
Okay, thank you.
Are you Ms. Kaiser?
Yes, ma'am.
All right, Ms. Kaiser, this is 22 CF 7309. You failed to appear for your trial management conference on February 14th at 2023. At this time, your bond is set at none. I'll appoint the public defender to represent you. And And you will see the judge in Division 15.
So
Okay,
you're gonna
thank you.
Judge in that division, you could talk to your attorney. Yep, that's why she's not touching it today, okay? Good luck. Oh, you cannot. You have no bond. You have no bond. You're gonna have to talk to your attorney, and you're gonna have to talk to them about a bond motion, and it's gonna be, and it's gonna have to be.
Sir, good afternoon. Are you Mr. McCall?
Yes, ma'am.
Mr. McCall, this is 23 CF 3753. You were arrested for possession of drug paraphernalia, resisting officer without violence, trespassing in a structure or conveyance, and possession of a controlled substance without a valid prescription. There's probable cause. I'll appoint the public defender to represent you. Your bond on count 1 is going to be, 100. Bond on count 2 is 100. Bond on count 3 is 100. It looks like there's 2 counts of that, so those will each be set at 100. And your bond on count 4 is 1,000.
How many total counts, Your Honor? I apologize.
If you look on the affidavit at offense number 3, if you go over to the 3rd column there where it says counts, there's a number 2 there.
Understood.
Okay. Thank you, Mr. McCall. Mr. Malcolm? Are you Mr. Malcolm?
Yeah.
Mr. Malcolm, this is 23 CF 3746. You were arrested for burglary of a dwelling while wearing a mask, grand theft, 3rd degree, and criminal mischief. There is probable cause. I am going to appoint the public defender to represent you. You are not to return to the scene. You are not to have any contact with the victim or witnesses. And you are not to possess any weapons or firearms. Your bond on count 1 is 5,000. Your bond on count 2 is 150. Your bond on count 3 is 100. And then I'm revoking the bond in 23 CF 1673. That bond will be set at none, sir. Thank you.
What about when you said the no bond, that's from my other charge?
Right.
And these new charges.
You have bond on the new case, but not on the old one.
I wasn't read my rights.
You'll have to talk with your lawyer about that. Thank you, sir. The hearing is concluded. Have a good day.
About that.
Mr. Maples?
Yes, ma'am.
This is 23 CF 3682. You were arrested pursuant to a probable cause warrant for grand theft of a motor vehicle and grand theft 3rd degree. I'll appoint the public defender to represent you. You are not to have any contact with the victim, co-defendant, or witnesses. You're not to possess any weapons and firearms or do not drive without a valid driver's license. Your bond on count 1 is 2,500. Your bond on count 2 is 150. Thank you, sir.
Herman Parson bonded.
Okay. You, Mr. Price?
Yes, ma'am.
All right, Mr. Price, this is 23 CF 3756. You were arrested for possession of MDMA. There is probable cause. I'm going to appoint the public defender to represent you, sir. How come Mr. Price didn't get interviewed? Do we know?
He was.
Oh.
Mr. Price was interviewed.
Did he qualify?
No, he's out on bond. You might be looking at Parsons.
Mr. Price is out on bond?
Mr. Price is out on bond.
I don't have a FAD.
I'm sorry, that was added before court.
The FAD was?
Yes, it's
Can you
in,
give me that case
it's in
number?
2021 CF 008322AO.
Sorry, 2021 CF.
008322AO.
Formal charges have been filed. He is set for trial April 3rd.
What kind of case is it?
It is trafficking in 28 grams or more of meth.
So, Mr. Price, at this time, your bond is set at $1,000, and I'm revoking the bond in 21 CF 8322. That's going to be set at none, sir. Yeah. Thank you.
To contact your attorney.
Your Honor, Scotty Richardson refused.
All right, I will find a waiver of his appearance based upon his refusal to come to court, appoint the public defender to represent him. In 21 CF 13094, he failed to appear for court. His bond is set at $1,000.
Jack Sharir is out of hospital.
Is medical? Okay, so I will have,
Your Honor, I did have just a brief PC argument for the driving while license suspended only.
No objection, Your Honor.
Thank you.
all right, hold on. This is 23 CT 2054, Jack Shearer.
Yeah, I didn't see it either, so.
Okay. I will release Mr. Shearer ROR when he returns from the hospital. As to that case. He has 23 CF 3750. He was arrested for fleeing and eluding, and in 23 CF 3751, he was arrested for possession of MDMA, possession of cannabis less than 20 grams, possession of drug paraphernalia, and resisting officer without violence. On that case, bond on count 1 is 1,000, bond on counts 2, 3, and 4 is 100. And then there's probable cause in 23 CF 3750, bond will be set at $3,500. And then he has reporting requirements when he's released from the jail.
And I apologize, is it waived or are we resetting to within 24 hours of his release?
Did you want 24 hours for it?
It's usually defense. I would ask for it to be waived, but
Your Honor, let me just check one thing. If he's being held no bond on something else, I'd want to reset it just so.
I don't know that he's being set, nope, it's on a different case, you mean, like something
Oh, no,
unrelated?
He's, oh, no, I apologize. It is this case. You put bond on it. We can waive his appearance.
Okay. So then I just ROR'd him on 23 CT 2054. He has bonds on the other cases. Okay. None, he does, based upon his sex offender status, he has reported. Mr. Sims? Yes, ma'am. All right, sir. This is 22 CF 8990, sir. You were arrested pursuant to a probable cause warrant for possession of cocaine. The offense date in that warrant, or alleged offense date in that warrant, is July 29th of 2022. The bond is $1,000. I'm not revoking the bond in 22 CF 2183. The date of arrest of that case is February 24th of 2022. However, Ms. Eugene, has the possession of cocaine been filed on in 22 CF 4073?
Your Honor, I think they've both been filed on, but the reason I hesitate is because I think there may be issues. They're set for status hearings, both on April 4th.
Let me take a look.
Question. Okay.
I'm dealing with conversation and all that. I've been working for a whole year.
So your attorney's gonna be able to explain more to you, but right now I wanna make sure that you have bonds, so let me check.
Okay. Upon further consideration and also reviewing the report that's in 22 CF 4073, I'm not going to take any action on those cases. And then, like I said, given the offense date of July 29th of 2022, I'm not going to revoke those, but the bond is set at $1,000. You have any questions, Mr. Sims? Okay, thank you.
So you can stay in touch with us? This doesn't have all your bond amounts on it, okay? This does not have all your bond amounts, just so you know. I didn't get to write them all down. You have some others, but you have bond on everything, okay?
Is Mr. Small?
Hold on one second.
Sir, good afternoon.
Resolved? I'll check it. You may not have come to court to actually accept that, so I'd have to check.
Sir,
Oh,
are
I'm
you,
sorry,
that's
man.
okay. Are you Mr. Small?
I'm so sorry, man.
That's okay. You don't have to apologize. Tell me your name.
Michael Small.
All right, Mr. Small. This is 22 CF 8384. You were arrested because you failed to appear for court on March 14th. At this time, your bond is set at none. I will appoint the public defender to represent you if they weren't previously appointed, and they'll need to get you in front of the judge in Division 14.
What kind of case is this, ma'am?
This is for possession of a controlled substance.
I did receive, I received a bond, and Mr.
Right, but you forgot to come to court, or you didn't show up for some reason. I don't know why.
Oh, Mr. Moncrief, I gave him another bond. I paid him for another bond, and I had got a letter in the mail on April, I had a case for April the 10th. I supposed to have a court date for April the 10th.
Let me see.
Because I paid Mr. Moncrief $200 to get me out of jail on this case.
That's for another case, it looks like.
Yeah, Mr.
got
Small,
trial
it's not on this case, but your next court date for this case is April 6th. So they'll make sure you get in front of the judge for that appearance, okay?
Yeah, but- So,
And if you contact your attorney, they might be able
You don't have a bond on this case right now.
I don't have a bond?
You do not on this case.
So,
talk to your attorney and then see the judge who's actually handling the case that has the PA out, okay? She's not gonna be able to touch it today. It's gonna have to go in front of the judge who has the case.
and when do I go to court on this case?
April 6th.
April 6th?
And if you April 6th isn't too far away, but if you contact your attorney, maybe they can get you in sooner.
Fuck me around.
Good luck.
Good afternoon, ma'am.
Yeah.
Tell me your name, please.
Ellen Soderholm.
Ms. Soderholm, this is 23 CF 3754. You were arrested for driving while license revoked as a habitual offender. I do find probable cause. I'm going to appoint the public defender to represent you. Ma'am, I'm going to release you on your own recognizance at this time. You are not to drive without a valid driver's license, okay? You understand? Okay, thank you.
Contact our office.
Mr. Longwell, how are you?
I'm well, how are you?
I'm well, thank you. Who are you here on?
Your Honor, Scott Thompson, which is the case coming now, he refused.
Oh, okay. Do you have that case, Mr. Longwell?
No, I have Scott Eklund, but apparently Scott Eklund and Scott Thompson have had some sort of altercation down in Brookings, so they're keeping them separate.
Okay.
That's why I guess they didn't bring them up.
Was Mr. Eklund excused for behavior? Is that what I was probably told?
That's what I'm gleaning from what I'm being told.
I can call the case back up to let you know what we did, or you want to be heard or anything like that on the case.
Sure, that'd be great. I can
Okay.
waive his appearance and advocate for him, I think.
Okay.
as best I can.
All right, let me just finish this part up here. Can you find Mr. Eklund's case for me? Okay, so I'm gonna set Mr. Thompson then, well, actually, did you say Mr. Thompson?
Refused, Your Honor.
You refused, okay.
Your Honor, that's the statewide case.
Yes. The attorney that's present for a statewide prosecution, could you tell me your name again, please?
Yep, Mary Salmon. I'm covering for Ashley Wright from the Office of Statewide Prosecution.
All right, Ms. Salmon. Thank you. I have 23 CF 3734. Scott Thompson. I'm waiving his appearance based upon his inability to come to court due to his behavior. He was arrested pursuant to a probable cause warrant for conspiracy to sell or deliver a controlled substance, 2 counts of conspiracy to sell or deliver cocaine, and unlawful use of a two-way communication device. He also was arrested in 23 CF 3747 for possession of fentanyl, possession of cocaine, and possession of drug paraphernalia. There's probable cause for those offenses as well. I will appoint the public defender to represent him in both cases. In CF 3747, bond on count 1 is 1,000, bond on count 2 is 150, bond on count 3 is 100. Ms. Salmon, I'm thinking you wanted to be heard on the warrant case.
Is that, I'm sorry, Your Honor, is that the case that you were just going over? Is that the one you were just speaking of?
Well, the warrant case is 23 CF 3734, and that's the conspiracy.
Correct, Your Honor.
Okay.
Well, the state would just ask that the bonds remain as set, and that Your Honor find the PC that was previously found by Judge Crestes.
Okay, yeah, I have, well, Ms. Fritchell, did you want to be heard?
Your Honor, what are the bonds currently at?
1,150, a subsidiary for the other 3.
Your Honor, I just want to make sure there is actually a bond in place on all counts.
There is.
Okay. And you said, so 1,100, and this is for the warrant case. I just want to make sure.
Correct, so it's 1,000, and then counts 2 through 4 are 150.
Let me just check one
And
thing.
then the conditions on the warrant are no contacts with co-defendants.
Your Honor, that seems as though a reasonable bond is in place and defense is agreeable.
Okay. And I have no reason to disturb the probable cause that was previously found. Anything else, Ms. Salmon? Or I guess you're here for Mr. Long, you'd be here for Mr. Longwell's case as well, is that right?
I don't think.
Not that I'm aware of.
They're not related cases. They just apparently had some interaction in booking.
Oh, okay. All right, well, thank you, Ms. Salmon, for appearing today.
Thank you, Your Honor. Thank you for allowing me to appear virtually.
Sure, take care. All right.
You are the only participant.
That's right. Good afternoon, sir. Tell me your name, please.
Jamel Watson.
Mr. Watson, you have 2 cases this afternoon, 23 CF 3745. You were arrested for possession of cocaine. There is probable cause, and I'll appoint the public defender to represent you on all the cases this afternoon. In that matter, your bond will be $1,000. And then in 22 CF 10261, you failed to appear for court on February 9th of this year, and your bond is set at none. You'll have to have your lawyer file a bond motion in Division 15. All right?
I had spoke with the bail bondsman not too long ago. They didn't tell me I had a court date coming up, that I had a court date on
Your
February.
Honor, I'd have to look into it more, but I know this is coming up a lot. I think there has been some issues with the bail bondsmen being notified of court dates. Something is coming to my memory that this was mentioned recently. I can double check my email, but this has been, I believe I've been notified that this is a reoccurring issue.
Well, let me just look at the court file.
I apologize, what's a reoccurring issue?
And I have to double check, it's just from my memory, I believe something came up from our office that bondsmen are not being notified of court dates. There's been some issue.
I'm gonna do everything I supposed to, y'all. So
Just a minute.
I found the email, I'm gonna see what information is in it.
So I'm looking at the notice that was sent by the clerk of the court on January 5th of 2023, and it was sent to the bondsman indicating that the arraignment in this case was set for February 9th at 8:30 a.m. and 18.
Your Honor, if we may approach with this email I have that kind of explains the situation in more detail.
Did Miss Eugene get to see it?
Sure.
Right, so unless I knew that for sure, which is certainly something they can do at a hearing on the case, but today, in order for me to modify this KPS, I'd either have to have Judge Weiss's consent, or I would do that if I had actual proof that the defendant didn't have notice, but I don't have either of those things, so I'm not gonna modify it today. Okay. Sure. Absolutely. Thank you, Mr. Watson.
Talk to your attorney and they'll help you out with that, okay? So, yeah, you're gonna have to contact your attorney and let them know that you weren't notified, and they're gonna have to do a bond motion in your actual decision, okay? Good luck.
Ma'am, good afternoon. Are you Miss Woodard?
Hi, honey.
Hi, ma'am. Are you Miss Woodard?
Yes, ma'am.
All right. This is 23 CF 3341. You were arrested pursuant to a probable cause warrant for burglary of an unoccupied structure, retail theft, and trespass on property. I will appoint the public defender to represent you. You are not to have any contact with your co-defendant or return to the scene. I'm going to place you on pretrial release, ma'am.
Okay, I don't understand where this was at, because
Yes, but if you can tell her where not to return to specifically, Your Honor.
Dynamic Auto Service.
No returning to Dynamic Auto Service, okay? Just don't go back there, and then you can talk to the attorney more specifically about the facts and what happened, okay? And then pretrial release, essentially, you're going to have a pretrial release officer, stay in touch with them, stay in touch with your public defender as well, okay? All right, good luck with everything. Thank you, Your Honor.
You're welcome.
Oh, yes.
Oh, this is Mr. Nguyen. Just a minute, Mr. Nguyen. Okay, all right. So, Mr. Nguyen, we had called you back to court this afternoon so that the lawyers could have a, and also the court, and some additional time to research the offense for which you were arrested for in the determination of probable cause. Did you wish to make any further argument, Ms. Fritchall?
Your Honor, defense would maintain their previous argument. Additionally, it was one single incident. Even if the length of the incident lasted for a few moments, that doesn't make it an additional incident. If the state is to argue that there were multiple victims, well, those would be different charges. For an aggravated stalk, it to be an aggravated stalking, it has to be a repeated incident. It has to occur repeatedly, I should say, with the same victim would be the defense's position. And therefore, there's no probable cause for that aggravated stalking.
Ms. Eugene?
Your Honor, I apologize. I'm looking for the language within the affidavit. I apologize.
I think I know the language you're,
It does talk, I apologize, I cannot pinpoint it, but it does talk about the continuity of purpose, Your Honor, and both the statute and case law says it's regardless of the amount of time. Within the affidavit, it does talk about the defendant allegedly following the girls, chasing after them for at least 0.15 miles. And the main purpose of a stalking statute is that the contact, if it is frightening, if there's no purpose for it. There was no purpose for this. They were definitely frightened as they ran away. And in addition, part of the defendant being out on bond or his probation was that he was to have no contact with any minors. He was attempting to have contact with minors, Your Honor.
okay.
And sorry, I apologize, Your Honor. Just to that point, that wouldn't change the PC argument for the aggravated stalking. Defense would just like to point that out.
I understand. So reading, I reread the statute. I looked at some cases regarding the conduct requiring multiple acts, which it does. But when I read the affidavit, there's three things that I think could constitute the multiple acts. One is the hollering, one is the following, or two would be the following, three would be the chasing. And for me, the tipping point, and I don't know in a trial if that would play out differently, but the tipping point for me also in this case is that a judge previously found probable cause in this case. So for me to disturb that previous finding of probable cause, I would have to be 100% certain that the facts did not meet a prima facie case, and I don't have that feeling. So I'm not gonna disturb that finding of probable cause at this time.
Understood, Your Honor.
Okay. Bond will be set at $3,500 on count one. On count two is $150. Sir, you are not to have any contact with the victims or any minors. You're currently on probation in 22 CF 4127. The court does find probable cause for a violation of probation, and in that matter, your bond will be set at none. And as I previously stated, I will appoint the public
Ma'am,
defender to represent you in both cases.
Ma'am, I have some problem with my mental and
And you can talk to your attorney more about that.
Okay.
I need a bond.
I understand. Your lawyer will be able to file that motion for you, sir, okay?
Contact
Thank you.
and talk to them more about it, okay? Good luck.
All right. Do we have Mr. Eklund? All right, this is a recall of 23 CF 3736. Mr. Longwell, you're representing Mr. Eklund?
Yes, good morning, Your Honor.
All right.
Good afternoon, I should say.
Yeah, right.
I think my mind was that I was gonna come this morning, and then I found out it was this afternoon, and
Yeah.
you guys are so early, actually.
Yeah, we were
Almost
today.
missed it.
Well, I think we all thought it was going to be a relatively smooth afternoon, and I think we were optimistic.
Yeah, and unfortunately, after last night, that didn't turn out like I wanted it.
I was a nervous wreck, and it was such a great game, and it was so sad
It
at the
was.
end.
They can hold their heads high.
Absolutely. I thought, it's one of the best basketball games I've ever seen.
It really was. It really was. My whole family, we watched it. And
Oh,
just,
so my son, who's 6, even sat and watched the majority of the second half with us, which I was shocked.
yeah.
But he did. But it was a great game.
Michigan State,
Michigan State.
lost to K-State in overtime. Close game. We both went to Michigan State.
Yeah.
So, did you know, I don't know if I've mentioned this to you, but did you know there's more judges that are Michigan State alum than Seminoles?
I did. There's
Isn't that amazing?
myself,
There's 6,
Sandor, Strobridge, Johnson, Cameron. Who's our sixth? Oh, and me.
Yes.
Me, yeah.
David Barrett told me that.
Oh, did he really?
Yeah, when I had lunch with him one day, he's like,
And so, yeah, great school.
all right, so Mr. Eklund.
Was he not coming up?
I don't think so. I think they have him for behavior
That's
downstairs.
fine. I just wanted to make sure. I didn't know if
Right.
something changed.
I'll go have a talk with him, though.
Okay,
So, I guess you already addressed it,
I did.
and I'm believing that you probably revoked his bond, right?
I did only on the 1460, which the date of arrest on that was February 1st. And then the arrest date for the battery domestic violence was 2/24, and that's the same date as the alleged offense date in the new warrant. That makes sense.
Okay. Yes.
I mean, I'm not asking you to agree with what I did. I just meant in terms of, do you understand what I did?
I do understand.
Okay.
I would, I'm gonna split hairs if you'll indulge me for a moment.
Sure.
And I just heard you articulating some points about disturbing the probable cause, but I've read the affidavit for probable cause on the warrant, and I'm confused, I guess, because the tampering, I don't think there's any doubt that there's probable cause based in that affidavit for contempt of court for allegedly having contact with the person he was ordered not to have contact with. The problem I have is the other count, which is the tampering with the witness, because the statute for tampering with a witness requires some facts alleging, in order for there to be a prima facie case, knowingly using intimidation, physical force, threatening another person, or attempting to do so, or engaging in misleading conduct, or offering pecuniary benefit. That's kind of the first step. I read over that report. I didn't see anywhere in there that there was evidence of that. I guess there's a suggestion that at some point the complainant said that he's been taking steroids and has been aggressive lately, but not necessarily in relation to this. The second one is that that behavior would be designed to effectuate one of the following behaviors, and I won't go through all of them, but basically withholding testimony from an official investigation, or altering or destroying or mutilating evidence, evading process, hindering or delaying, preventing communication, things like that. I saw no suggestion of that. What I see is a suggestion that he contacted her and instructed her, I think was the word, to go talk to her lawyer, meaning my office, to give what could be truthful testimony. I'm assuming, well, we wouldn't take anything other than truthful testimony at my office, but it doesn't say, he said anywhere, go make up a story, or go say this, or go do this. It says just go talk to him. And for all I know, she might want to decline prosecution. She might want to give information that would tend to establish mutual combat or a defense for my client. I don't know what her testimony is because I've never met with her. But that's the problem I have with the probable cause affidavit. Other than it establishing that there's been contact, it doesn't really establish any behavior to perpetuate an illegal course of conduct. So I would argue that there's just not probable cause for that count. And I know I'm splitting hairs because it doesn't change my client's status.
Right, right. And I understand your argument, and there may be a proof problem later on down the line, but like I had just told Ms. Fritschall, there had already been a determination of probable cause, and in order for me to disturb that on a warrant, there would have to be really strong, clear-cut facts for me to say that it's completely wrong, and I don't get that feeling. I was just looking up the other case. Is it all the same people that are involved in all of the cases? So I'm looking at the the driving license suspended, the attempted burglary of an occupied dwelling, and the criminal mischief.
So those were not charged other than the Dwellis. That's the only charge that came out of that. So an information has been filed, and the only case that count was charged was Dwellis, which is gonna be a tough one for the state to make too, but,
Ms. Eugene, did you want to be heard?
Your Honor, my only response would be, when reading the affidavit, I'm sorry, I have a number open and I switched. What is this?
Is this the gentleman that we thought needed a Turkish interpreter?
wouldn't think so. He's.
No.
I'm mixing up many people
Sure.
today. This is the second time I've done this today. Okay.
I apologize, Your Honor. I'm going to paraphrase while I look for the actual,
Which one?
for Scott Eklund with regard to.
No, I mean which case?
Oh, the 23 CF 3736. With regard to that, Your Honor, it states that defendant has been contacting her and that she is afraid of retaliation if she did not go to Mr. Longlow's office. So I believe that there is enough probable cause with regard to
Oh, agreed.
the intimidation and what have you.
I mean, I agree
Already
that.
won that one.
Other than that, Your Honor, I would actually ask that you revoke the 23 MM 1301. He was arrested February 24th, and then after that, he continued to have contact. That's why it is a contempt of court, because he was ordered by Judge McGinnis to not have contact with her. So based on that, I would actually ask that you revoke actually on 23 MM 1301.
I received today a state's emergency motion to revoke bond in 1301, just in all candor to the court. They are seeking to revoke. I do believe that the arrest on that case was February 24th, 2023. And this arrest in this new case is March 23rd, 2023, based on allegations of continued contact. There has not been an information filed in that case that I know of as of today. In the other case, there was an information, and as I said, no charges were filed other than a driving while license suspended. I believe that's an accurate picture of at least the history. So he's out on bond on 2 cases.
Right, right. Well, now that I know about the nuance of the arrest of 224, I would feel more comfortable keeping his bond set in the Dwellis case than I would in the battery case.
I understand, and I wanted to clarify that for you for probably that reason. I mean, the alleged victim in the domestic violence case is Brittany Wiley, and she's the same person who he's alleged to have contact with and have encouraged or asked to come and give a statement to us. Which I'm gonna ask him if he's just lost faith in my ability to do my job.
Okay. Based on everything that's, well, I think what I'm gonna do, since there's already this motion to revoke bond set, I'm gonna flip-flop the cases today, and I'm gonna leave the bond set in the Dwellis case. It's got court dates. It looks like it's set. You can go in circuit court and handle that case. And then I'm gonna revoke the bond in the misdemeanor case based upon his contact with her after the court order had been entered. And then you can all go talk to Judge McGinnis. You'll have time to talk to Mr. Eklund, and then that whole issue can be addressed in the division.
That makes sense.
Okay, then that's what we'll do. Madam Clerk, did you want me to say that again? Okay, so in the 23 MM 1301, bond is revoked and set at none. And then in the 23 CF 1460. Just take no action on that case. And then I left everything the same on the warrant case, on the new case.
Would you consider, or do you want to leave it to Judge McGinnis whether to set a new bond in the MM case?
I'll leave that to Judge McGinnis to do.
Didn't hurt for me to ask.
Nope, never does. Nope. Do you have anything else, Mr. Longwell?
I believe that's it.
All right, and I think that's everything for us as well. All right, court will be adjourned.
Vamos a renunciar a la lectura de los cargos.
Good morning, sir. Please state your full name.
Buenos días, caballero. Por favor, su nombre completo.
Felipe Orozco González.
Good day to you, Felipe Orozco González.
All right, sir. I've read the police report. I find probable cause for the 10 listed offenses.
Muy bien, yo he leído el informe de la policía y encuentro que hay motivo fundado para los 10 cargos que se han enumerado.
Your bond will remain $2,000 for each count for an aggregate amount of $20,000.
La fianza va a permanecer en $2,000 por cada uno de los cargos para un total de $20,000 de fianza.
Should you make bond, you're not to be in possession of any electronic device capable of accessing the internet.
Si usted pudiera salir bajo fianza, no debe tener acceso a ningún artículo electrónico que pueda tener capacidad de utilizar el internet.
Your next court date, you'll receive.
Su próxima fecha en el tribunal le va a ser notificada más adelante.
Just a moment, the state attorney's office, assistant state attorney has some input.
Y la fiscal tiene algo que decir.
Your Honor, state is asking for additional conditions of bond, no contact with minors, and no possession of any device capable of data storage.
La fiscalía está pidiendo condiciones adicionales que como parte de la fianza no pueda tener contacto con ningún menor ni tener ningún artículo electrónico que tenga capacidad para almacenar datos.
The court deems those to be reasonable conditions based upon the affidavit and the contents. So you must not possess any device capable of data storage.
Muy bien, el tribunal entiende que son peticiones razonables basado en el contenido de las alegaciones y por lo tanto el tribunal está incluyendo que está prohibido que posea ningún artículo electrónico que tenga capacidad para almacenar datos.
To be particular, that would be an electronic device capable of electronic data storage.
Para ser específico, tiene que ser un artículo electrónico que tenga capacidad para almacenar datos electrónicos.
You're not to have any contact with any minors.
Y no puede tener ningún contacto con ningún menor.
Next court date will be provided. You'll receive it.
La próxima fecha ante el tribunal le va a ser notificada más adelante.
Thank you.
Muchas gracias.
Just let me know, Ms. Catano, when the need for the interpreter is finished. Is Pedro Rivera, does he need the interpreter, Pedro Rivera? All right, Mr. Sotomayor, we'll recall if necessary. Thank you.
You're welcome, Your Honor.
Pedro Pablo Rivera. All right, sir, good afternoon. You've been arrested on a warrant out of Orange County. The case number is 22 CF 37560. The issuing court on a violation of community control has set your bond at 0. It will remain 0 at this time. Your next, or actually Orange County will have a reasonable amount of time to pick you up. Thank you.
Thank you.
Christian Rosa. All right, Mr. Rosa, good afternoon. Been picked up on a warrant out of Orange County. It's a violation of probation on a grand theft. Your bond is 0. It will remain 0 at this time. Orange County will have a reasonable amount of time to pick you up. Thank you. Stuart Wood. All right, Mr. Wood, you've been arrested on a writ of bodily attachment with a purge amount of $25,000 in DR 10477. This is out of Orange County. Orange County will have a reasonable amount of time to pick you up. Thank you. Fernando Alcantara. Public defender appointed.
Your Honor, he bonded out.
He bonded. Okay. Moving along, Michael Bassler. Michael Bassler. Mr. Bassler, you've been arrested for a failure to appear warrant out of Judge Karsten's division. Judge Karsten did grant you a bond in the amount of $5,000. This was for a failure to appear at pretrial conference in case 22 CF 1801. Your next court date?
Pre-trial, April 25th, trial period beginning May 9th.
April 25th, pretrial conference, your next court date. Thank you. James Hill Alston.
I believe he bonded prior.
Okay. Bonded, apparently? Thank you. Christian Pelot or Palat.
He's in detox, Your Honor.
He's in detox. Okay. We'll reset him for tomorrow. Those were 2 FTAs, failure to appear for sentencing. Fausto Ramos. All right. Good afternoon, Mr. Ramos. You've been arrested on I will appoint the public defender. You've been arrested on an outstanding violation of probation warrant in case 21 CF 3648. And Judge Young has set your bond at 0. There's actually an amended affidavit as well. Your next court date will be provided.
April 3rd, 8:45.
Question, Your Honor.
Yes, sir.
I do have proof of my probation officer coming to my house. I was in need because I was hospitalized for 2 months. So they were visiting me at the house. And I had an argument with my mother. So therefore, was that the violation because the cop?
Well, there's multiple bases for violation. Failure to pay cost of supervision is one, failing to complete your community service hours, failing to report. However, I don't adjudicate the matter today. That would be up to Judge Young and any defenses you have, either for the ultimate hearing or for why you might be granted a bond, would have to be addressed to Judge Young, but I understand you're wanting to let me know that. All right, thank you. Tommy Alvarez Torres. Hello. The paperwork I have, Mr. Alvarez Torres, indicates that you're waiving your right to have an attorney. Do you not want a lawyer?
Yeah, I do want a lawyer.
Do you think you have enough money to hire your own?
I don't know.
Well, I don't know either. How much cash do you presently have?
Not that much.
I'm going to make a provisional appointment of the public defender's office, and I'm going to provide the state with 24 hours to supplement the record. There's a circumstantial case for probable cause based upon a generalized observation of a hand-to-hand, but it lacks particularity. And so I'm going to reset this initial appearance for tomorrow. Your bonds will remain as they've been set. I'm not making an affirmative finding of no probable cause. I'm just giving the state 24 hours to supplement the record. Your bond is $1 million on count 1, trafficking fentanyl with a firearm, $1,000 on the remaining 2 counts for an aggregate amount of $1,002,000, and this will be reset for tomorrow.
Your Honor, would you allow the state to make a?
Of course. If you could put the microphone up to your mouth so we can all hear you. Go ahead.
Your Honor, state would argue there's enough for probable cause on all 3 counts, and if not, to find probable cause under Principle 3, Florida Statute 777.01. The officer observed Mr. Alvarez Torres walk over to, the co-defendant, Mr. Robert Ortiz Roldan, walk over to Mr. Alvarez Torres, retrieve an item, and the agent testified that that exact item was given to him.
Where's that? Where did you read about that exact item? If you could point me to that in the affidavit.
Yes, Your Honor. I'm looking at page 2, Your Honor, paragraph 1, 2, 3, 4. Where defendant Ortiz Roldan walked over to the Dodge Ram, meeting Mr., which was occupied by Mr. Alvarez Torres. And I'm sorry, Your Honor, actually, the next paragraph, it says that Mr. Ortiz Roldan waved to Mr. Alvarez Torres, who was identified as the driver later on in the black Dodge. He approaches the front passenger side window of the black Dodge Ram, is seen obtaining an item. After obtaining the item, he walks over and meets Agent Rodriguez. Sorry, it's broken up here. And then I guess we jump back to the paragraph before that, where Mr. Roldan meets Agent Rodriguez, and they exchange the suspected 40 grams of fentanyl in exchange for $2,400. State would argue there would just be no other reason for Mr. Alvarez Torres' presence other than handing Mr. Ortiz Roldan the suspected fentanyl that is used in this transaction, Your Honor, and under principal theory, state believes that's enough to find probable cause, Your Honor.
Ms. Catano?
Your Honor, when I read this, I thought the report was confusing and not specific enough for probable cause, but I'll leave it up to Your Honor.
All right. I read the exact report that you read, State, and I understand the circumstantial inference that's drawn. It just needs to be a little more particularized. You used language that I didn't see in the report, which would presume that there was language in the affidavit about why the officer would know that the exact same item that was given from this defendant to the other co-defendant was the same item that was then sold. And so it just needs to be more particularized as to the facts on that point. I understand your argument and your reasoning, and perhaps a fact finder tomorrow will concur, but I'm nevertheless giving you 24 hours to supplement the record in case law enforcement can particularize the affidavit with more detail. All right, and I agree with your principal theory. The issue for the court is not whether it's sufficient for principle. It goes more to the issue of the particularities with the contraband itself being the same contraband. All right?
Your Honor, the defense objects to a 24-hour reset on the four corners of the affidavit. At this time, there's no probable cause.
Well, and the reason I'm allowing 24 hours is because it may very well be the court's reluctance to find probable cause in this particular instance could be very well a failure to provide more particularized detail rather than simply a construction of the facts. So over your objection, I'm going to go ahead and grant 24 hours to supplement the record. All right, thank you. All right, sir, your initial appearance will be held tomorrow, but you still enjoy the same bonds that were put on the police report for now. Thank you. Brandon Braxton. Public defender appointed. Hello, Mr. Braxton. Public defender's been appointed. I find probable cause for petty theft. Ms. Jenkins, any history? There's other legal constraints, apparently.
With his other legal constraint, he have a warrant out of Virginia. For the state of Florida from 2021, petty theft, disorderly conduct, 2022 petty theft, 2022 aggravated assault with a deadly weapon, resisting officer without violence, commit theft, recovery of property, possession of drug paraphernalia, battery, 2022 again petty theft, resisting officer without violence, smuggle contraband into a prison, firearm, weapon or explosive, trespass, occupied structure out of the state of Virginia from 2012 to 2017 to contempt of court, failure to appear, shoplifting, obtain money, false pretense, contribute to delinquency of a child, misdemeanor good behavior, violation of whatever that is. Virginia is different. Felony drug, conspiracy, aid, abet, shoplifting, 2019, intentional damage, arson, dwelling, usually occupied. 2020, failure to appear, trespass, resisting officer without violence, failure to appear, larceny, drug possession, felony, that's 2020. 2020 also, possession of drug paraphernalia. And that'll be it, Your Honor.
All right, a number of years ago, Florida courts mandated that courts grant bond if an offense is not capital or punishable by life. So defendant enjoys an entitlement to some bond that's reasonable based on the history and the totality of circumstances presented. I'm going to set your bond at $2,500, and you're not to return to the Walmart at 3250 Vineland Road, and your next court date will be provided. You'll receive. Thank you. Jane Doe, 632, also known as Velma Whitelie. Sir, good afternoon. Your name?
Paul Gezzi for the defendant, Judge.
Your last name again?
Gezzi, G-H-E-Z-Z-I.
All right, Mr. Gezzi. I would inquire of corrections whether or not the defendant's identification has been established with from the FBI or with any particularity.
Yes, sir.
Okay, and who would it be?
Velma Whiteley.
Okay. Can you, is that spelled? And this is perhaps explains the pronunciation.
Like a white lie.
Okay, all right. That's, I got it. All right. Counselor, did you want to be heard at all?
Yes, Judge, I have read over the report, and I think there may be a lacking probable cause, and at least for the burglary count and the obtaining property count. Here she was the one that actually purchased the property. There's no allegations that it was never paid for, or that it was paid for by someone else's money or anything like that. They went on vacation to their own timeshare, and I guess they're alleged that it was bought with a fake ID. I don't know if that would constitute a burglary if she's the one that actually purchased it, and it says in the report that they did purchase it.
All right. State any response.
Your Honor, my understanding he's just arguing PC on count 2. Is that correct?
He argued PC for 2 different offenses, I think. Well, count 2 is what I heard, yeah.
And the obtaining property, Judge. I don't think
And count 1.
Your Honor, on count 1, state would argue that there is PC. She's using a false identity. The victim advised that her identity was used to purchase the timeshare, gave the exact date, the amount, and where it was purchased. And the victim has been in contact with law enforcement. And also, the defendant did not provide her proper ID when the officers arrived on scene, and she hasn't been identified until now. For count 2, state has no argument and would ask the court to find probable cause on a trespass.
Your Honor, if I may, I would just point out that there's no verification of the victim's ID. I mean, they said that they call her the victim, and they say that she said it was her ID, but there's no evidence to actually verify who she was. They spoke to someone on a phone.
Okay, I reviewed the affidavit in detail, and I understand the arguments, but I do find probable cause for all 4 listed charges, including burglary. The bonds will be $25,000 on each count for a total of $100,000, and the defendant is to have no contact whatsoever with the alleged co-defendant in the case, that individual being John Doe, also known as Christopher Ricketts, known as John Doe 3255, and not to return to the property being 7700 Westgate Boulevard. Your next court date will be provided. You'll receive. Thank you.
Judge, could I possibly be heard as to the amount on the bond?
Yeah, I think part of that factor was potential flight risk, given what's in the police affidavit or the charging affidavit with respect to identification issues for both. But you can be heard.
My clients, they have 2 kids that they're taking care of, and also an Alzheimer's patient mother. They live in Fort Lauderdale. They've been there for 20 years. They've already retained the services of a law firm to represent them, which indicates to me that they intend on appearing here, Judge. And I don't think that they could afford bonds that high. That's tantamount to no bond in this case. And also, they are a couple. I don't know, I think you ordered no contact. But
I did. That'll have to be taken up with the trial court, all right? So this is without prejudice, obviously, for filing a motion and putting more facts before the court. I'm limiting my findings to the sworn affidavits I have. All right, thank you. Moving next to Christopher Ricketts, John Doe 3255. Yeah, your hearing's over. Thank you. Christopher Ricketts, John Doe 3255.
And Judge, I am also appearing for them for limited purposes of the first appearance.
Okay, I assume you have the same or similar arguments?
I do, Judge, except I think with his, I don't think he has a burglary. I think he just has, I looked at his, it looked like there's 2 counts, possession of a fraudulent ID, and the burglary. I would make the same argument as to the burglary. I mean, I believe they said that the woman was the one that her ID was used. There's no indication that he was the one that used it. He thought he was lawfully there because they were the ones that purchased the property, Judge. So.
State.
Your Honor, State would argue that Mr. Ricketts or John Doe 3255 was well aware of what the co-defendant was doing. He was not forthcoming with his identity. Surveillance video also showed both of the suspects checking into the timeshare unit. The suspect, both
Admitted to making entry. Yeah, go ahead.
I'm sorry, and both the male and female purchased and gained entry into the timeshare together. So State would argue there's enough for probable cause for both counts, Your Honor.
Yeah. All right, respectfully, I've understanding the arguments, I do find probable cause for counts 1 and 2. Bond will be $25,000 on each count. Defendants, until further order of the court, defendants to have no contact with Velma Whiteley, John Doe 632, and not to return to the location 7700 Westgate Boulevard. Next court dates will be provided. You'll receive. All right. Thank you, Counselor. Thank you, Mr. Deasy. Michael Foley.
He refused? He refused, Your Honor.
He refused. Okay. Well, that'll constitute a waiver. He's got a bond of $500. He should have come. I could have considered direct PTR, but I'm not going to do that under the circumstances. So he's got a bond of $500, and he doesn't need to be reset. Carmen Isela.
He's in the back, Your Honor. They're getting him.
Okay. Public defender appointed. While that's taking place, Ms. Jenkins, history?
From 2020, possession of drug paraphernalia.
You've been muted. Hang on a minute. All I heard was paraphernalia, and you got muted.
I'm sorry.
That's all right.
2020, possession of drug paraphernalia. 2022, battery DV. That's out of state of Florida. Out of state of South Carolina. 2019, shoplifting, ag assault, resisting officer, assault on a police officer, give false info, shoplifting, and 2020 shoplifting.
All right. Mr. Isela, I'm setting your bond at $1,000. Should you make bond, you're to have no contact with Tina Myrtle Davis. You're not to possess or consume any alcoholic beverages, not to possess any weapons or firearms. Your next court date will be provided. Yes, sir?
I was just trying to get back to work. I live in Florida now, and I was going to get back to Myrtle Beach and handle my business, but there was the stuff that happened.
You just got muted. All right, are we finished?
Yes, Your Honor.
All right, thank you. Markel McMorris. Markel McMorris. Public defender appointed. All right, Mr. McMorris, there are two listed charges. The court does not find probable cause for, I find probable cause for one battery. If you look at the face of the charging affidavit, they're indistinguishable, but I find, so I'll find probable cause for the battery that's listed as charge number 1, and that is, so everyone's aware, that's the battery that's alleged to have taken place against Bridget Granberry. With respect to the other matter, there's inconsistent versions of events from the two parties without any sufficient corroborating information to find probable cause on the battery against Corbin McMorris, as there seems to have been mutual combat. Now, in terms of bond, Mr. McMorris, I'm setting your bond in the amount of $500, subject to pretrial release supervision with the following conditions. Until further order of the court, you are not to return to 775 Star Magnolia Drive in Kissimmee. Now, I presume that you have personal belongings there, such as clothing, toiletries, perhaps items for work, so I'll grant a one-time return with the assistance of law enforcement for those items. You're not to possess any weapons or firearms, and you're not to have any contact with Bridget Granberry, and you're not to have any contact with Corbin McMorris, and your next court date will be provided. Thank you. Howard Oliver.
Good afternoon, Judge.
Good afternoon, Mr. Oliver. What did you say? Public defender. I'm appointing the public defender to represent you in this matter. Just one second. Is Mr. Geezy still there? I might be mispronouncing his name. The private attorney? Oh, he's gone? Okay. Just a second. All right, Mr. Oliver, I've reviewed the police report. I find probable cause for all 6 of the listed charges. I also find that there's concerns of flight risk. Count 1, your bond is $100,000. That's on the burglary. Your bonds on the remaining 5 counts will remain the same, $250 on count 2, theft, $250 on count 3, theft of utilities, $500 on possession of multiple counterfeit credit cards, $1,000 on obtaining property or services under $20,000, and $1,000 on possession of 2 or more counterfeit credit cards. Your next court date will be provided, and you're not to return to 8949 Zurich Lane.
Sir, can I speak?
You can.
All right, you say you found, I'm not, ma'am. You say you find probable cause for the first charge. So I'm not a flight risk. I was born in Orlando, Florida. My whole family lives in Florida. I am no flight risk.
Okay.
All my kids are here, my family's here. Where am I going? So I'm no flight risk. Sir, I got a whole family I'm responsible for, and I understand the charges before me are very serious. But they are just accusations, sir. I have a whole family to support. All I want to do is get out and support my family until court, until I can prove these charges are not right, because I signed a lease. But I'm not going to go into that. But I'm no flight risk, sir. My whole family lives here. Please, sir, I need to get out of jail. I can't get out of jail with a $100,000 bond. I'm responsible for 5 girls.
Okay.
Please, Your Honor.
All right. So part of the reason for the court's finding of a flight risk were multiple identifications with your picture but different identifications. You can take this up with the trial court, but those are the bond amounts for now. That concludes the hearing. Next court date? You'll receive. Thank you. Robert Ortiz Roldan. Public defender appointed. All right, sir, good afternoon. There's 2 cases. First, you've been arrested on an outstanding warrant, and the bonds will remain as they've been set, which is $100,000 on count 1, trafficking fentanyl, $100 on count 2, delivery of drug paraphernalia, $150 on count 3, unlawful use of two-way communication device. And then there is a separate case, 23 CF 909. Just a moment. I actually have a question about this. Let's see. And that is the proposition that they're two separate and distinct cases. I just want to make sure of that because the agency number is the same.
Yes, Your Honor. Under 23 CF 909, the incident date is March 23rd, 23. Under the warrant,
It's 427.
it's April.
Yeah, okay, that's right. All right, and in 23 CF 909, which is the case that I read because I had the content of the affidavit before me, I do find probable cause for the listed offenses. Your bond will be, as set, trafficking fentanyl, 4 grams or more, $500,000, delivery of drug paraphernalia, $1,000, and unlawful use of communication device, $2,500, for an aggregate amount of $503,500. Should you make bond, you'll be supervised by pretrial release. You're not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription. You're also to have no contact whatsoever with the alleged co-defendant in the case, that individual being Tommy Alvarez Torres. And your next court dates, Madam Clerk? You'll receive. Thank you. Yeah, those conditions are for each case. Thank you, Madam Clerk. That's for each case concerning no contact and no possession. Miguel Reyes. I believe Ms. Sharon Munoz is here and present for this case. All right, sir. Good afternoon.
Good afternoon, Your Honor.
I will appoint the public defender to represent you in this matter, and if you didn't hear, I believe your mother is present. She can hear and see what's taking place at the moment. I have reviewed the police report. I do find probable cause for the listed offenses, count 1, battery, count 2, hindering a witness's communication, and count 3, false imprisonment. Before I determine conditions of release or bond, Ms. Jenkins?
Your Honor, in 2021, 3/12/2021, 21 MM 705 for petty theft, he had a notice to appear and it's still open.
Okay.
And that's the only thing he have, Your Honor.
All right. Any contact, I know you left a message, any direct contact with the victim?
No, sir.
All right, sir, I'm setting your bond at $500 on count 1, battery. I'm setting your bond at $250 on count 2. And I'm setting your bond at $250 on count 3 for an aggregate of $1,000. Should you make bond, you're to have no contact until further order of the court. You're to have no contact whatsoever with Ms. Victoria Morales. You're not to return to 3 West Marbrisa Way in Kissimmee. If you have personal belongings there, such as clothing, toiletries, or items for work, I'll grant a one-time return with the assistance of the sheriff's office. And you're not to possess any weapons or firearms. Your next court date, you'll receive. All right, thank you. Thanks. Yes, ma'am?
My son and Victoria have never been married, and they have a child in common. Can he ask for parental?
He's going to have to talk to his lawyer about putting a motion before the trial court that has the case about making some accommodation for childcare. But I don't have enough information before me right now to sort out some type of custody exchange or anything like that.
And then I would like to ask you another thing, Your Honor. Your Honor, they both hurt each other, okay? My son was never read the Miranda rights from the officer never did that, first. And second, they both hurt and they both agree, fight each other, okay? And then the police said, I'm not gonna arrest her because I
Ma'am, I'm not permitted to consider anything you tell me. I have to base my decisions on sworn affidavits. There's always more to a story than I have at initial appearance. All I have is the charging affidavit, so I don't mean to be dismissive of you. But I'm really not to consider any third-party information that's not sworn testimony and it's not in the form of an affidavit. So what you are telling me may be very important to the case, and the state attorney is here who's responsible for prosecuting it, and he also has a defense attorney who's responsible for defending him. And so they would need to have whatever information you deem is relevant. All right? I believe I gave him an aggregate bond of $1,000. It was $500 on count 1, $250 on the remaining 2 counts, if I remember correctly. Yes, so that's $1,000. And so if you went to a bondsman, it's customary for them to have like 10% for them to work with you. All right, have a good day. All right. Stephen Seidnor. All right, Mr. Seidnor, good afternoon.
Good afternoon.
There are 4 listed charges. I don't find PC for count 3, which is use of a firearm during the commission of a felony. I do find probable cause for possession of cannabis more than 20 grams, possession of drug paraphernalia, and count 4, carrying a concealed firearm. Before determining bond, Ms. Jenkins, history?
2/7/2019, he had a failure to appear for use of drug paraphernalia out of Polk County and possession of marijuana out of Polk County. That's all history he have, Your Honor.
All right. All right, just a second. How much cannabis was it? I'm actually going back and looking for the weight of the cannabis.
Your Honor, if I may.
Yep.
On the second page, first paragraph starting with upon searching.
Yep.
About 6 lines down, it says an ounce, which is approximately about 28 grams.
Right.
That Mr. Seidor advised the officer he had about an ounce.
Okay, just a second. So I'm going to modify what I just said. I'm going to find probable cause for the lesser included offense of possession of cannabis on count 1. I'll set bond at $500 on count 1, $500 on count 2, possession of drug paraphernalia, no PC, ROR, released on own recognizance at count 3, and I'm going to maintain the $1,000 bond on carrying a concealed firearm. Mr. Seidnor, if you make bond, you're not to possess any weapons or firearms during the pendency of this case, and not to possess, ingest, or consume any illegal substances or any controlled substances without a prescription. Your next court date, Madam Clerk? You'll receive. Thank you. India Williams.
She's in the back, Your Honor.
Okay. Public defender appointed. Okay.
She's approaching, Your Honor.
All right, Ms. Williams, good afternoon. Hello. I reviewed the police report. I find probable cause for battery on a corrections officer. Your bond is $2,500, and your next court date, you will receive. All right, public defenders appointed. Thank you. All right, Elias Santana. Still medical. Still medical, okay. All right, so that, I believe, concludes our business, unless there's something we missed. Do you think that concludes the business, Ms. Cateno?
Yes, Your Honor, we're going to reset that, right?
Yes, we'll reset that for tomorrow. All right.
Your Honor?
Yep.
I just want to confirm, I have Hill Alston, James Hill Alston. Was that? Okay.
Yeah, I think I called it, but it was bonded, so. You do?
Yes, I have that.
Angel Saldana, okay. Yeah, okay, he refused. I think I did call that, but he refused. Yes, he's, him and Isaac and El-Hijah, I think, are partners, allegedly, huh? Okay, let me see it. This is the one that you addressed. Okay, then, so Ms. Jenkins correctly has pointed out that I neglected to address it, I guess. I thought I addressed it. Okay. So Angel or Angel Saldana, why is he's not in there he refused, so I find by his refusal that he's waived his initial appearance and the bonds will remain as they've been set, which is $3,500 on count 1, $100 on count 2. He's also not to have any contact with co-defendants Isaac Blanco and, let's see, the other fella whose name is a little more difficult to pronounce. No contact with any alleged co-defendants, put it that way. All right, thank you. Everyone, have a good weekend. Ms. Jenkins and Ms. Cateno, we're in recess. And state.
Thank you, Your Honor.
Yeah.